Good evening, everybody, and welcome to the Law&Crime Network's Daily Debrief. I'm Jesse Weber, in for Aaron Keller tonight. Harvey Weinstein is back in the hospital after learning he'd be going to prison for 23 years. Weinstein's legal team tells us that Weinstein's suffering from a perfect storm of health issues: dangerously high blood pressure, a recent heart procedure, a concussion from this past weekend, and spinal problems. Medical staff at New York's Rikers Island Hospital determined Weinstein should be shipped back to Bellevue Hospital, where before sentencing, Weinstein underwent angioplasty and the installation of a stent in his heart. Weinstein's publicist said earlier today on the Law&Crime Network that Weinstein was devastated when Judge Burke issued the 23-year sentence.
Harvey had a Sandoval motion in front of him that nobody knew. It was under seal, that we weren't allowed to discuss, that if he were to testify, every bit of bad acts he ever did, and not sexual crimes or anything like that, even yelling at Bob, punching Bob in the face, whatever, everything that came out in those mysterious leaks that came out the day before sentencing would have been brought up, and those people would have been brought to testify in front of the jury as well. So when he finally had his opportunity to speak, he wanted to speak. And what he says, he is remorseful for the type of person he was, for the kind of person he was. He was a bad person. He was an awful boss in some ways. Did he commit crimes? No. So would he say he's sorry for committing a crime? He wasn't going to do that. Is he sorry that people feel bad the way he treated them? Yes. Is he sorry that he let his family go because of it? Absolutely. But is he sorry for committing a crime? Once again, no, he doesn't believe he did. And you heard him say it to Jessica and to Miriam yesterday. He said, "I'm hoping that some part of our relationship is, of the good parts, are still remain with you," because he genuinely believes they had a relationship, genuinely believes it was consensual, and genuinely believes that they liked each other. And to him, this was a surprise.
Engelmeyer said that Weinstein will return to the city jail in New York when he's medically able. He's hired a consultant to prepare him for his ultimate prison placement.
The way the process works is, if, barring the medical issue, he would go back to Rikers Island, which he did, and 3 to 7 days later, he gets transferred to Fishkill, which is a processing center for all prisoners, and then from there, he gets assigned to his final place. It could be Fishkill, it could be another one of the upstate prisons. Craig has been preparing him for being in upstate prison to the best he can, telling him what to expect, but not just helping him emotionally prepare, but also helping him navigate and making the request of DOC as necessary as well. We heard the same thing that I got the same phone calls from media telling me that there's a call to extradite him to LA. We don't know yet. We're looking at that. Our lawyers will do what we think we have to do on that. But in theory, he will go be arraigned in an LA court and then come back to serve a sentence here in New York. And then once the trial is ready to begin in LA, they will send him back to LA for the trial. For the LA portion, it's not clear who the attorneys are going to be for that yet. I'm not at liberty to discuss what team is being put together right now, and we don't know what the final team is.
New York prosecutors dropped charges against Weinstein involving accuser Lucia Evans after a detective failed to disclose that a corroborating witness contradicted her account of what happened. An attorney for Evans said Los Angeles prosecutors have already reached out to her.
She's strongly thinking about it. It was such a difficult experience to spend so much time and emotional energy on the New York case, and then for it to just be dropped. So it's a big decision, but the LA case is important too.
Now, the women are not only talking about criminal justice reform, they're also supporting a New York bill which would allow the adult victims of old abuse cases to sue for damages. The bill is similar to New York's Child Victims Act, which opened the floodgates of litigation for institutions like the Boy Scouts and the Catholic Church.
The Adult Survivors Act, which we're pushing in Albany, which will give survivors of sexual assault the armor to bring cases themselves and to hold their abusers accountable in civil court. And right now, we've seen our government has a complete monopoly on who gets prosecuted, whose cases to take seriously, what cases to investigate, and we've seen that the prosecutors decided to charge two survivors' cases out of the over 90 survivors that were abused by Weinstein. So with the Adult Survivors Act, we'll have a 1-year look-back window when survivors everywhere of sexual assault can take their cases to civil court and hold their abusers accountable themselves. And the fact of the matter is that when somebody has committed a sexual assault against you, that's a malicious, deliberate act they should have to pay. And we should all have the right to be able to sue in civil court.
Filipino and Italian model Ambra Gutierrez says she's also looking into helping with the Los Angeles case. But she hasn't forgotten that this Manhattan District Attorney's Office declined to prosecute Weinstein in 2015 after she recorded him as part of a sting operation.
They didn't contact me. I think they don't want to reopen, let's say, skeleton in the closet. So they should say sorry. I did everything I was supposed to be done. And I did it in the way that every person should be doing it. And now that's what I'm trying to do, is fight for people to feel more safe to come forward. And also something that I'm working with Safe Horizon. It's the Adult Survivors Act. And so as I did something to change my future, I would love to give that opportunity to other people. So I hope I could do that, and I'm really working for it because I know that this is the first big example and that is the start, so we need to really keep working.
Four guests are with us tonight, but let's begin with one of Weinstein's attorneys, Imran Ansari. Imran, it's great to have you here. A lot to talk about. I'm going to start from right now. Have you seen Mr. Weinstein today? What is the latest?
Yes, Jesse, first of all, it's great to see you, and it's good to see you back in the studio and not outside 100 Center Street. Yes. So I saw Harvey yesterday, obviously, after the sentencing. Today I was supposed to go, but I had another court appearance in the morning. But Harvey is in Bellevue again. And just to dispel some of the rumors out there, he didn't have a mild heart attack. And being cognizant of my client's rights under HIPAA, he did have elevated blood pressure after the sentencing. This is what sent him to Bellevue largely after the conviction. After the conviction, he suffered from elevated high blood pressure at a dangerously high level. He suffered that again after the sentencing. So the Department of Correction, in the abundance of caution and making sure that my client receives the proper medical treatment, transported him back to Bellevue rather than Rikers, where he was at the North Infirmary Unit, where he's being treated right now for the medical conditions. He has the high blood pressure, and despite a lot of people thinking that he was malingering with his back and the walker, he has serious injuries to his back that he's dealing with, and he's also dealing with the heart condition and a concussion that he's suffered from. So right now, I've said it before, it's a perfect storm of health problems for Harvey. But that aside, he remains focused on his defense, the next steps, that being the appeal, getting ready to defend against any charges and the charges coming down in L.A., and also the civil cases he's facing. He remains steadfast to defend those.
Imran, let me ask you about that. The conviction and the sentence, how is that going to impact the potential civil claims against him?
Sure. So after the conviction, I represent Harvey on a number of the civil cases. After the conviction, the civil attorneys have all inquired about, the discovery process in those cases. These cases weren't formally stayed, but of course, with the criminal action in progress, there was some back burner to it. It was put on the back burner. Now, with conviction and the sentencing, the civil matters are very much alive, and that's something that my client's going to have to deal with. And at this point, he intends to defend those matters just as he intends to defend himself on appeal and also in L.A.
All right, Imran, I want to get one more question from you if I can. I saw you in court. That's the last time I saw you. I saw you constantly throughout this trial. Do you think that Judge Burke was ready to impose that sentence even before the day started, or was he persuaded by something that he heard in court?
I think Judge Burke had that sentence ready to go. Now, listen, there's some questions about how Judge Burke treated the defense during the course of this trial. I think those things will be really best answered on appeal when the appellate review is done on this trial record. And there's various things that we feel that, there were some decisions by Judge Burke during the course of this trial that will be reviewed by the appellate term. And we intend to sort of get the clarification on those rulings and those actions then. But I think Judge Burke had it in mind prior to the sentencing, prior to the speeches in court, as to what he was going to be sentencing my client to. And I think it's swayed not necessarily by the trial, not by the evidence, but by the court of public opinion and pressure that he may have felt to impose a certain sentence, which I feel is out of line in accordance to.
That is something that's been echoed by the rest of the defense team. Surely, we saw it yesterday. And Imran, I know we have to let you go, but appreciate you taking the time to explain the latest.
Absolutely, thank you.
Thank you. All right, so our other guests are with us, but I'm not sure we have enough time to get to them about the Weinstein case, but I want everybody to stick around because there is a lot more to discuss on the program. Next up, attorneys for so-called doomsday cult mom Lori Vallow are demanding a new judge, and the case against her is barely getting started. Vallow is charged in Idaho with deserting her missing children, ages 7 and 17. Her defense team wants the judge assigned to the case removed and a preliminary hearing postponed. Now, under Idaho law, any party can demand a new judge, but preliminary hearings must occur within 14 days if a defendant is in custody. The defense wants an extra 3 weeks to review discovery material. Day 3 of deliberations in the trial of an Iowa mother accused of strangling her 5-year-old daughter to death with a pair of pajamas. The victim of the alleged crime was Kelsie Thomas. Prosecutors say defendant Kelsie Thomas confessed to the killing. The defense says the confession was coerced and called an expert on false confessions with these findings.
These are some of the points that we documented. Were first mentioned by the investigators. At one point, one of the investigators said, "What happens when you come back in and look at her? She's still in the same spot, wasn't she? Is that when you knew that maybe you had pushed too hard?" They repeatedly told Ms. Thomas that her confession must match the medical evidence and told her exactly what the medical evidence showed. One of the investigators suggested that Chloe's shirt was pushed upwards and might have caused the marks around Chloe's neck. Ms. Thomas responded that she might have. She was so angry. The opinion that this was a highly coercive interrogation, the kind of which that could lead both to a guilty person providing a true confession or an innocent person providing a false confession.
All right, so the defense, they pushed for this false confession, but we have a lot more here on the program tonight. Still ahead tonight, an update on the prosecution of real estate heir Robert Durst. Then to Michigan for the trial of a man accused of slaying three members of the LGBTQ community. Find out if the state is any closer to identifying the defendant as the gunman. An update now on the California murder case against real estate heir Robert Durst. Durst is accused of killing his friend Susan Berman in December 2000 because he feared she was going to run to police to disclose that Durst had killed his wife Kathleen back in 1982. Kathy Durst is legally declared dead, but her body has never been found. A neighbor testified this morning that Kathy crawled in through a window to escape her husband one night in the 80s because he had beaten her. The defendant's brother also testified this morning under subpoena that he's scared of Robert. Now, cameras aren't allowed in court during they're only allowed during opening statements and closing arguments, but you can listen to audio of these witnesses on the Law&Crime YouTube page. The state is rested and the defense will call no witnesses in the trial of a Michigan man accused of killing 3 people and shooting 2 others. Alante Davis and Timothy Blanchard, both gay men, and Paris Cameron, a transgender woman, were killed in a house in the early morning hours on May 25, 2019. 2 others witnessed the attack. Prosecutors say defendant Devon Robinson shot and killed the victims. The defense says the witnesses cannot definitively name Robinson as the shooter. Now, one of the victim's boyfriends said the defendant was quiet when he came to the party. This witness left the gathering, so he wasn't there when the shooting happened.
Still there. Not much happened for real with communication with everybody. As far as him, our mind did indicate that he knew him.
And at some point, did Mr. Robinson go upstairs?
Yes.
Did other individuals in the house go upstairs?
Yes, 3.
Okay, so there was oral sex that happened in the house that
Yes.
night. Did you participate in that?
No.
Did you have an argument with Armand regarding what had been happening in the house?
Yes. I was asking all day to leave the house.
All right, but you left the house at some point after the argument.
Yes.
Did you see Mr. Robinson leave?
Yes. He left about 5 to 10 minutes before I left.
Before the argument happened?
No, after.
And when you were finally able to leave, how did that happen?
When I left, originally Lance drove, but he was too drunk to drive, so I had to end up driving home.
On cross, the defense seemed to be pointing out possible other suspects, including a man who had been dating victim Paris Cameron and who was at the house earlier in the night.
Because he didn't want anybody to know his sexual preference, but we already figured.
And he kept asking for Paris for money, correct?
After, we all had, the party, whatever y'all would call it.
You indicated in your statement that he kept asking Paris for money, correct?
Yes.
And then he also asked where Paris kept her purse at, right?
No. Yes, Paris did hide her purse, but it did not happen like that.
So your statement on May 25th wasn't true?
It was true.
The detective spent hours questioning the defendant, even lying to him about DNA evidence and video surveillance. The defense questioned this tactic on cross-examination.
He never admitted shooting anybody, did he?
No, sir.
You approach him like you're going to be his advocate and go to the prosecutor's office and do him a big favor. Do I have that right?
Yes, sir.
Your intention isn't to go to the prosecutor and be his advocate, is it?
Well, the evidence will be given to the prosecutor.
You're not acting as his advocate when you go to the prosecutor's office, are you?
Argumentative.
I'm judging legitimate cross-examination.
Well, you've already asked the question and he already responded. Sustained.
A woman who used to live with the defendant saw him leave that morning but not come back. Now, you're going to be able to tell from this testimony that she was a hostile witness.
All I said was when I woke up, I can't tell you if it was Friday or Saturday. When I woke up, he was asleep, got up, took a shower, ate, played with the kids, and left.
All right, the night of the shooting, where were you?
I never heard no shots because when I get off work, I work 12 hours at Chrysler 4. When I get up and when I go to sleep, I'll sleep to the next day. I never heard
Ma'am,
no
that
shooting.
wasn't the question that was posed to you.
Do you know who was killed in this case?
No.
This is not the first time you've testified.
No, I don't. I don't know who was killed, and I don't know who killed nobody.
Did you commit a homicide?
No, I did not.
Did you leave 3440 Buckingham?
Did I what?
Did you leave your home on Buckingham on May 25th in the early morning hours and commit a homicide?
No, I did not even leave, period, until I got ready for work again.
And closing arguments are set for Monday. All right, let's turn to our panel, who I wasn't able to get to before. Joining me tonight is Gigi Gonzalez, an attorney from Miami, Dina Dahl, an attorney from LA, and of course, forensic death investigator from Jacksonville State University, Joseph Scott Morgan. Great to have you all here. Gigi, I want to start with you. What do you make of the defense calling no witnesses?
I don't make much of it. The defense doesn't have to put on a case. It's the state's burden to put on a case, and the state has to prove beyond a reasonable doubt that the defendant did this. And so far, they've got, a shaky timeline and a blurred motive. No eyewitness, no DNA, nothing that can put the defendant at the scene of the crime at the time of the murders.
That sounds like a closing argument that we're going to hear Monday. So, Gigi, it's great to have you on to talk about the perspective. Now, Joseph, I want to get to you about the shooting. What can you tell us about the shooting, in your opinion, that maybe helps to identify the shooter? What are we not seeing?
Well, this is key. Has the prosecution actually put the weapon into his hand and have him firing the weapon? And that's very difficult. I got to tell you, Jesse, one of the most compelling things about this case to me thus far, watching it earlier today, is this examination of the detective on the stand and how he kind of approached this young gentleman, with using deception, all this stuff, which police are perfectly within their rights to use. This is going to play with the jury in a very specific manner? Are they going to see this as an attempt to entrap this fellow? And thus it goes to the weapon. Well, can we actually validate that he held the weapon at all? This guy was lying to him to begin with. And the jury might not be aware of this, but if you're deceptive in the interview process, then that's all fine and good, but you're going to pay a price for it on the stand.
And look, you look at the weapon, and you look at the gunshots, and you look at the wounds that were sustained. Whoever did this intended to kill these victims.
Yes.
Now, Dina, I want to turn to you. What do you make of this alternative suspect theory? Is the defense at this point raising reasonable doubt, and is it enough reasonable doubt?
They have to have some sort of theory here, but I agree that it seems like the prosecution really, they can place him there earlier in the night, and they're trying to just have this connection that he was angry kind of as a result of his interaction with them and came back and did it. They're trying to give him a motive. But without this eyewitness testimony or anything else, I don't know if it's going to be enough to go through reasonable doubt.
Well, it'll be up to the jury, and there's a lot for them to consider. All right, let me go in-house. Joining me is New York Public Defender and also host here on the Law&Crime Network, Brian Buckmeyer. Brian, great to see you. Is there something about what the detectives did that you feel was improper in the way that they questioned Robinson? Is there something that wasn't right?
So there's something that's not right, but to Joseph Scott Morgan's part, it's completely legal. The way in which they're trying to lead him down the path of incriminating himself, obviously he doesn't follow those tactics, and lie after lie, he doesn't incriminate himself. So I think if you construct a good cross-examination of this officer, you can make him seem like the bad guy here. But if you don't do it properly, it can just seem as business as usual. And so it's really up to the perspective of that of the jurors.
And it's going to be up to both sides how they want to characterize this interview. The prosecution one way, the defense the other. All my guests, great tonight. You gave a good preview of what a closing argument would ultimately look like, and we'll wait till Monday to see it. So thanks everybody for coming in tonight. I appreciate it. And thank you all for joining us tonight. Now, our live trial coverage resumes tomorrow at 9 a.m. Eastern Standard Time on the Law&Crime Network. The Debrief is live on Law&Crime at 5 o'clock Eastern. For all of us here, have a great night.